Welcome, everybody. I see some familiar faces out there and some new faces as well. I know some folks might be new to Backcountry Hunters and Anglers as an organization, and so I wanted to give a quick introduction to the group and what we do. We are a North American nonprofit organization that focuses on access and opportunity to public lands, waters, and wildlife, and also focuses on ensuring that we have healthy populations of fish and game to pursue when we get there. Another focus of ours is fair chase hunting ethics, and that's something that we always keep in mind when we're out in the fields. And that sort of sets the tone for the high levels of work that we do. My name is Mike, and I'm a volunteer here in New England for the New England chapter of Backcountry Hunters and Anglers. And I think that we have a lot of folks from Rhode Island in the room, but for those of you who are not, we have chapters all over North America. I think at this point it's all except for one state in the United States, and then a couple Canadian provinces as well. So wherever you are, there's a chapter of Backcountry Hunters and Anglers out there working for your access to public lands and waters. Tonight, we've got an awesome event focusing on public trust and access to the shoreline here in Rhode Island. And we have a couple great speakers on that are going to be presenting information on the topic, and then information on how you can get engaged in the process of speaking up for your rights and speaking up at the legislature here in Rhode Island at the General Assembly. So I want to turn it over quickly to our speakers to give a quick introduction for themselves. And first, I'll turn it over to Dennis Nixon.
Good evening, everyone. My pleasure to be here. I moved to Rhode Island in 1975 from the Midwest, where we had easy access to all the coastal lakes there. And I was stunned at how difficult it was to get to the shore when I got to Rhode Island. And the very first lease of my first apartment said I was not allowed to walk across the lawn to get to the water. And that offended me, and I've been pissed off about it since 1975. And I've been trying to do something about it since then. And the bill here we're talking about tonight is an effort to try and right that wrong. Sorry. Yeah, there we have it.
No, that's awesome, Dennis. Thank you. And then I'll turn it over to Representative Corbrand.
Good evening. Thanks for having me, and thanks for the work that Backcountry Hunters and Anglers is doing in this area. And I kind of got interested in this because I was interested in sea level rise. And when Scott Keeley got arrested on the beach, somebody sent me the article, and through my investigations, I ended up meeting up with Dennis, and that's how this bill, that's kind of the origin of the bill. But I'm Terry Cortfriend. I'm the state representative for southern part of Portsmouth and the east part of Middletown, and I'm in my second term serving District 72. And thanks for having me tonight. I look forward to the conversation.
Outstanding, Terry. Thank you so much for being here. I want to sort of start digging in with Dennis at the beginning, right? So I think a lot of the people here maybe have heard of the concept of public trust doctrine or the resources that are held in public trust. But starting at the very beginning, can you, Dennis, sort of go through the concept? You know, what does that mean, and where, you know, what was its origin? How did it sort of become?
Sure. I wasn't there when it happened because it was in the 4th century AD when Justinian, the Roman emperor, who was also a pretty good lawyer, came up with the first legal code that we recognize today in Western civilization. And in the Justinian's code, they held that the land underneath flowing waters had a special character. It wasn't like the kind of land that could be normally bought and sold. There was a public interest that remained in this land. And concept has been living with us since the 4th century. It was first recognized in 1841 in the case of Martin v. Waddell, 1841, a fight over an oyster lease off the coast of New Jersey. And two guys were fighting it out, one who had a claim from the King of England, one who had a claim from the state of New Jersey. It was important that the state of New Jersey have the right to decide over the future of its own tidelands. Well, anyway, United States Supreme Court, 1890, upheld this concept of the Public Trust Doctrine, and it's been a cornerstone of American public resources law ever since then. It was an effort to give away much of the submerged lake bed of Lake Michigan to a railroad. And the Supreme Court said, wait a minute, you can't just give away all of this public land to one particular party without any particular purpose. And the idea that, well, we might hire some people later to fill in the land and build some warehouses, that just wasn't enough. So that concept has been with us ever since in federal law. Rhode Island, this has been a subject that was so important that it was first raised in the King Charles Charter of 1662, in which the inhabitants of this state were granted a charter. And among the things they were allowed to maintain were the so-called privileges of the shore. And that mostly related to the rights to go fishing. And this was not a really small thing at the time, because this was a period in England in which the common citizens were often not allowed to go fishing on the king's waterways. Only members that were given permission by the royal family could actually go catch a salmon in that stream. So the idea that the inhabitants of the colony were granted this right to go fishing along the shore was really a big deal in 1662. And it distinguished this state from others in that the citizens here, the folks who went over, Roger Williams and Mr. Clark from Newport, who went over to negotiate these charters, really insisted on that this was an important thing to Rhode Island inhabitants. And this later became part of other states' charters, but Rhode Island was the first state to really insist on this in our colonial charter. Unusually, even after our independence, after the United States of America, we continued to be governed by this colonial charter. There were some interesting things that happened in Rhode Island history, the Doors Rebellion, which I know you know about now, that eventually resulted in the state deciding maybe we should have our own constitution. And finally, in the 1840s, we developed a state constitution that made it a lot easier for someone who wasn't a white male who owned property could actually vote. And so this was a pretty dramatic change in the political structure of the state. The Constitution repeated the phrase privileges of the shore, and they didn't define it too carefully, but the impact was that the people of the state had these special rights. And that's where things stood pretty quietly for a long time until 1957, when the General Assembly was confronted with a number of disputes over rights of way along the South Shore. And they created a commission to explore public rights of way to the shore. And their idea was they would start in Westerly and they would move their way east around the state's shoreline. The problem was they never got out of Westerly because every single right of way was disputed by coastal property owners. And so the commission ended up in disarray. They worked several years, basically didn't get much done. But it did lead to an important realization that became part of the state's coastal management program. The public access to the shore really was a big deal, and we should do things to both maintain and restore access and make it open to more people.
So I want to sort of jump in here because we've jumped up through sort of big chunks of time, and we mentioned the 1840s with the first version of Rhode Island's Constitution, which included language I think that was very similar to what we have today, but sort of in a pared down fashion. And then all the way up into the 1950s, with the creation of that first Coastal Access Commission. But I want to sort of fast forward a little bit to the 1980s, because there were a lot of interesting events that sort of happened that set the stage for the conversation that, that's going on in Rhode Island today about coastal access. And the two ones that sort of stuck out to me and that I heard mentioned by a lot of folks in the hearing in the House Committee on Environment and Natural Resources a couple of weeks ago was the Ibison case and then the 1986 Constitutional Convention. So can you sort of start with, what was the climate in Rhode Island leading into 1982 when Ibison was arrested, and how did that all come to be? And I think there's that interesting, almost conversational aspect where, there was this reaction and then another reaction and then another reaction that ended up with the Constitution that we enjoy today.
Well, one of the advantages of age is I remember all this stuff pretty clearly. The 1970s were a period of very high growth in the South Shore coastal communities. We saw a significant transfer of population from Pawtucket, Providence, and Cranston. People said, why do we just, make our way down to the beach in the summertime? Why don't we buy one of those new houses that are being developed in all those subdivisions in Narragansett, South Kingstown, Charleston? And as a result, there was a very significant addition of people and people want to live along the shore. So previously wide open areas were now being developed as single family homes. And as soon as you began to sell those large tracts of land off, which had largely been publicly accessible because the property owners didn't care, and people began to have some friction. The property owners and the public began to disagree on what their rights were. And that led to a boiling point in 1982 in the so-called Ibison, Rhode Island Supreme Court decision. That case involved 6 fishermen, sport fishermen, who were engaged in a beach cleanup in Westerly, Rhode Island, and they encountered a Mr. Wilfred Kay, who owned a waterfront property in the Watch Hill area. Mr. Kay had followed what he thought was the appropriate law from the U.S. Supreme Court, Los Angeles versus Borax, that said that the mean high water should be the appropriate boundary. Certainly alleged that he did the proper survey and he knew exactly where the boundary was and he marked it. And as soon as these fishermen ventured across the line, he had contacted a Westerly patrolman and said, "Officer, arrest these people because they've trespassed across my property. I've warned them. They've continued to walk along this property above what I have determined to be the boundary." The 6 fishermen were indeed arrested and they were arraigned. They went to trial, and ultimately their case made it to the Rhode Island Supreme Court. And the court had to do a couple of important things. Number one, they had to reaffirm that in Rhode Island, we followed the doctrine that was first expressed in 1935 in a US Supreme Court case called Los Angeles versus Borax, which said that mean high water really was the appropriate boundary. Now, just a bit of explanation here. The mean high water boundary just sounds kind of nice, but it's rather complex to figure out. It requires averaging the high tides over the entire 18.6 year lunar cycle. You know that every day the high tide is, it's 3.0, 3.2, 2.8. It varies significantly depending on the relationship between the moon and the earth. And as a result, you've got to do a fairly significant mathematical computation and then go back and figure out exactly where that fits on the current profile of the beach. An easy way to do this is if you've done the math and you know that, for example, on your part of the coast, the 18.6 variation is 3.1 feet, as is the mean high tide. You can then go to your tide chart for that day of the month when the high tide is at exactly 3.1 feet at 2.08 in the afternoon. You can go stand on that spot, and that's where the boundary is that day. But if that night a coastal storm comes through and erodes the beach by 3 feet, the boundary moves inland 3 feet the next day. So it's a boundary that you can determine, but it is definitely not the kind of boundary that lawyers like, where you have meets and bounds and fixed landmarks. This is a moving boundary depending on how the shoreline moves in and out. Many of you know that our beaches migrate in and out with the season. The winter beach profile looks nothing like the summer beach profile. So determining where the boundary is on a day-to-day basis is a tough job, but it was the solution endorsed by the US Supreme Court, and I think the Rhode Island Supreme Court felt compelled to follow it. Now, of course, not every state does that, but we decided to do it that way.
I was impressed as I sort of dug into this issue and research for, the hearings that happened a couple of weeks ago, at the sheer complexity of trying to determine where that boundary occurs, between needing to average such a long range of historical data and understand that, but then even more importantly, somehow superimpose that on, the diagonal shoreline going from, underwater to up on the beach. And, as somebody that sort of walks on the shore, I fish and, clam and, walk up and down the shore, thinking about how a guy like me would actually figure out where I'm allowed to walk and not allowed to walk based on that boundary seems completely impractical.
Because this case was about fishermen that were arrested. And the Supreme Court said, well, we got to figure out where the boundary is. But in the end, they said we could not convict these people. And the reason was, and this is in a direct quote from the Rhode Island Supreme Court, the basic due process provides that no man shall be held criminally responsible for conduct that he could not reasonably understand to be prescribed. In other words, even if you think you're trying hard to figure out where the boundary is, you don't really know where it is along the shore. And therefore, all those defendants lack what we call in legal terms the mens rea. They lacked the guilty mind. They couldn't possibly have known they were committing a crime because they didn't know where the boundary was. They thought they were doing the right thing. And the court went on to put a really tough burden on coastal communities, which I know they would like to get rid of. Every one of those coastal communities, from New Shoreham and Westerly and Charleston, Narragansett, and so on. The court goes on to say this: in the future, any municipality that intends to impose criminal penalties for trespass on waterfront property above the mean high water line must prove beyond a reasonable doubt that the defendant knew the location of the boundary and intentionally trespass across it.
I want to sort of close out on the Ibison case, but it sounded like the outcome of that case was actually that, even though these people, may have been above where that ownership line occurred as the court determined it, they didn't actually get convicted of trespassing because they couldn't have reasonably known. Is that correct? That's
correct. And that's been true in all of the subsequent trespassing cases that have been brought against individuals since then. And that's why, I said to myself a couple of years ago in a discussion with Terry, this can't go on. This is stupid. We don't need a new blow up every summer over the same issue when we could simplify this and make it easier for the public to exercise their rights without offending the private property owner's security of the title in their own property.
Sure. Well, I think that's a good place for us to transition right now to talking about the bills that are before the General Assembly, and one of those in the House and one of those in the Senate. The House bill is H5649 and the Senate bill is S0521.
S5469. I think you're
H5469.
H5469.
Yes,
yeah.
and
I'm throwing off the first part, but
and I'll thank you, Representative Cortreven, for introducing that bill, for being the one that brought that to the General Assembly both last year and is it just 2 years or is more than that?
Well, it never got a hearing last year because of COVID. So we put it in last year, but it never got a hearing. So this is the first year, in my mind, this is really the first year it's been introduced. Got a little press last year, but we never had the hearing.
Yes.
But can we go back and ask Dennis one more thing? Because
absolutely,
we didn't talk about, when we got to 1986, what's in the Constitution now, because that's really, to me, where, we have the boundary, the legal boundary, that nobody can tell exactly where it is unless they do all the scientific, analysis. And then we have the guy walking along the beach. And I think it was well, you tell us, Dennis. Well, you were there, so.
Yeah, it was a tough situation because this was a very a period of heightened anxiety along the shore, shall we say. And when there was a call for a constitutional convention in 1986, when they asked the public what issues they cared about the most and they wanted to revisit, access along the shore was one of the top issues that they raised. So this had to be part of the Constitutional Convention's agenda. And just as a refresher, when the Assembly calls for a convention, which they do every 20 years or so these days, the public appoints delegates and they debate issues and they come up with suggestions. And in this case, there were about a dozen suggestions, changes to the state constitution that were then sent to the voters for approval. I was asked early on by the chair of the subcommittee on public access, George Sisson of Westerly. Westerly seems to focus a lot on these discussions of shoreline rights, to help them because I was a professor at URI and I wasn't representing, I was a member of the bar, but wasn't representing any property owners. And he saw me as maybe somebody could speak on behalf of the public. So I assisted the committee in the development of the amendment that ultimately was sent to the voters and was adopted as part of the Constitutional Convention in 1986. It was, in fact, it was the ballot issue that won by the highest plurality that year. And I was urged by the convention president, Kevin McKenna, to get as much as you can for the people. And I cautioned that, I am a trained lawyer and I know about the Fifth Amendment of the Constitution that says that thou shalt not take a private property without just compensation. And if we just said that, like Oregon does, that the beaches are open to the line of vegetation, there would be a huge takings claim against the state of Rhode Island. I didn't want to see that happen because we couldn't afford it. However, I was trying to at least guarantee the rights that in previous years, the Rhode Island Supreme Court had granted to the citizens of the state. Because my fear was we were seeing a fairly conservative Supreme Court at that time, and I feared that they would take back some of the rights they'd already given us. And those rights were the right to pass along the shore, the right to fish along the shore, third for bathing, and fourth, my favorite, the right to gather one cartload of seaweed for your garden from the shore. And those had all been holdings in different Rhode Island Supreme Court cases. And I said, if we put these in the Constitution, no subsequent Supreme Court can ever take them away. So let's at least nail down the rights we have. That was Article 17 of the Constitution. Article 16 of the Constitution, which was part of this effort, said that as we define what the public's rights are, they should be considered broadly considered and not to affect the private property rights of individuals who happen to own property along the shore. So the public's rights should be broadly construed against those of a private property owner. And that certainly wasn't enough to create any excitement regarding a challenge under the Fifth Amendment of the United States Constitution. So this passed. It didn't do everything people wanted, and it didn't really resolve that fundamental problem of where the hell the boundary is on a day-to-day basis. And this is the one troublesome point. We otherwise have some pretty good rights in our Constitution, but the problem has been coastal property owners calling the police on people like all of you with a fishing rod who just wanted to walk along the shore to cast your line, which the last time I checked is a right in the Constitution. And as long as coastal property owners can continue to pay most of the property taxes in many coastal communities, they get the attention of their police force more quickly than you folks do just walking down the beach. So there's been an imbalance here that the bill that Representative Courtmain has proposed attempts to right that balance, to thread the needle between the public's rights to use the shore and private property owners' rights to be certain of where their boundary is for the purposes of their title and transferring title to a subsequent purchaser. I'm not suggesting in this bill that we change anything to do with that mean high water line, but I am suggesting that based on what the Ibison decision said, because it's so darn hard to determine where mean high water is on a day-to-day basis, we need to take away that criminal sanction. I want to decriminalize the act of trying to exercise your constitutional right to have access along the shore. That's all this bill tries to do. It doesn't impact anybody's property rights. And it is, I think, a nice answer to the annual struggle in coastal communities over people being, I want you to arrest that man. Well, I think I'm doing the right thing. This would solve that problem. And I think it would be a significant amount of relief among the police chiefs, at least on the South Coast, who wouldn't have to be dragged into these disputes between property owners and individuals like all of you.
So one of the questions that I had, Dennis, when I first started digging into this, one of the things that stuck out to me was that, the topic initially seemed like one of access, or maybe one of fish and wildlife, or, land use. But the bill was placed into the criminal offense category of law, and really focuses on an exemption to criminal trespass. The thought process there seems as though most of these issues are related to people being prosecuted criminally for using a right that there's sort of this mismatch, right? Was that sort of the strategy, and that plays into the sort of the balance of public and private rights? Can you sort of comment on that just a bit?
Well, I've never suggested we challenge the boundary of mean high water. What I've always suggested is that since that is so difficult to determine on a day-to-day basis, it doesn't make sense to use our tax dollars to enforce a boundary in which, so far as I can tell, no one's ever been convicted of trespass. In fact, as we've discussed earlier, Mike, in the most recent expensive trespassing case, the town of Narragansett was forced to pay the last person arrested $25,000, which came from Rhode Island Interlocal Insurance Trust, which is financed by all the cities and communities of Rhode Island. So our tax dollars go to pay the interlocal trust, which went to pay the legal fees of the person who got arrested in Narragansett. This doesn't make any sense. This is not good government. This is stupid government when our tax dollars are going to bail somebody out of jail because he shouldn't have been charged with a crime, because you can't have that guilty mind when you don't even know where the damn boundary is.
So the way that I've sort of put that in, in trying to talk to people about this issue, and I think I may have said it during the House hearing, was that what we need is something that lets us figure out where, who's breaking the rules and who's not, using a tape measure instead of using a judge.
Right.
Well, I think the simple solution as provided in the bill that is under discussion is one that will take a lot of the air out of the wind of a lot of the folks who are making grand pronouncements on this. If we can just say that there's a bit of a demilitarized zone here, 10 feet from the last recognizable high water, and we're not taking away anybody's rights here. We're just trying to guarantee that there is a balance between the public's rights and the private right to own property. It's not a right that is in any way inhibits the rights of the private property owner to use and value their own property. There's no diminution of the property value as a result of interpreting. In fact, we're not changing the boundary. We're just saying that we don't believe it's worth public resources to go after someone when so far those cases have never merited a conviction.
I want to ask a question about some of the language in the bill. One of the things that, also that I noticed as I sort of dug a little bit deeper was the language of sandy and rocky shore. And so the follow-on question would be, some of the sort of the shoreline has been developed with, things like seawalls or, special, more rugged barriers to, either prevent erosion or prevent, the ocean from coming up into somebody's house and washing it away. Can you comment a little bit on the sort of sandy and rocky shore language, and, how would this affect the developed section of the shoreline?
I think
Sure,
it doesn't. Well, you can go ahead. I was going to say it doesn't.
Well, the Rhode Island Supreme Court has actually given us a pretty good ruling on this in the Greater Providence real estate case some years ago, in which I had argued that the Hall versus Nascimento opinion in the Rhode Island Supreme Court around 1990 found that a particular part of the shoreline in Portsmouth, in Terry's backyard, had been filled due to an action of the Army Corps of Engineers, and the question is whether or not the state continued to have a public trust interest in that property. Well, they found that the state did, because in that particular case, there had been no specific action by the General Assembly to allow that filling to occur. I argued unsuccessfully that all of those properties that have been filled in the upper part of the bay, starting in Newport and working your way north, but much of the harbor, as you know, in Providence has been filled over the years, and in Cranston, Newport, Wickford, Bristol, you name the coastal community up in the bay, they've engaged in significant filling. So the question is, would there be a continuing public ownership, public interest, public trust in those properties? And the court said no. If the property had been filled and bulkheaded appropriately according to the law at the time, public rights were extinguished. So what this means is, if you're walking on a sandy, rocky shore, and all of a sudden you get to a part of the shore that has been bulkheaded and now has bent grass growing on top of it, you don't get to keep walking. The public has surrendered those rights on parts of the developed shore that were properly filled and bulkheaded under the laws that prevailed at that time. So this is really about the part of the shore that is much more dynamic and moving. I live in Jamestown, which has a granite shore that doesn't move very much at all. It's affected by sea level rise, and that's about it. Whereas the South Coast beaches, from New Shoreham to back to the mainland, from Westerly to Narragansett, have significant movement of those boundaries, and that's where this has been most problematic. And this solution would fix that problem very nicely.
So I realize, just sort of looking at some of the questions that are coming in, that we sort of dove right into talking about some of the more nuanced issues on this bill. But I do want to sort of circle back and just at a very high level, give an overview of what's being proposed here. We've talked about sort of the simplification or the establishment of a boundary, but as we're proposing it, what is the proposal to actually do? What is the boundary, and how would that, if I was walking down the beach, how would I determine what it is and where I could be?
Terry, I think that one's yours.
Okay, well, yeah, somebody sent me a photo of the shore behind Portsmouth, which is much more like Jamestown and not overly dynamic. I actually sent the picture to Dennis to have him see if he came up with the same answer I did, which was the lowest rack line because that from the photo, that's visually what you could see. Maybe if you were standing there in person, there might be some other clues that would tell you that the most recent high tide wasn't quite there, which is kind of what the person that sent me the photo is arguing at this current date. But 10 feet from the most visible evidence that you're standing from landward, but that it wouldn't include infrastructure. This is not in the bill, but I'm actually think we have a better chance of getting the bill passed if we consider a sub A that is explicitly says that it doesn't include infrastructure, docks, seawalls.
Right.
And it also, the other thing that it doesn't do, it doesn't preclude the property owner from taking civil action. If the property owner wants to pursue something on their own with their own money, it's just saying we're not going to use public resource dollars to engage law enforcement in this.
Yeah, that's a very important point. We're not taking away the boundary. We're just telling the property owner, if he feels so deeply about it, he needs to file a civil action against the parties that are doing the trespass. Trespass is both a crime and a tort, or a private wrong. And we're not doing anything to take away your private right to go after someone for trespass. And a lot of people have mentioned the concern of the property owners that, well, this is going to subject us to all sorts of bogus lawsuits, people saying I slipped on the seaweed. But the General Assembly addressed this issue a long time ago when they passed the Rhode Island Recreational Use Statute, which said that when property owners are either required by, say, the Coastal Management Council or volunteered to, or by direction of this law, required to let the public pass across what might be their property, they are not subject to claims for negligence. And that's a really important point. It insulates them from any kind of illegal action that might happen when the public is exercising their public rights in this sort of so-called demilitarized zone or decriminalized zone along the shore.
It doesn't talk about littering either. And I'm just going to give a plug for my coastal access cleanup people. The biggest complaint I hear from property owners is the garbage that's left behind. So I'll just take my minute to implore anybody that's going to exercise their constitutional right to walk across somebody else's land to please take your trash with you and not leave it behind. Because that's one of the biggest complaints about allowing this to move forward.
Yeah, and I'll second that. As an organization, Backcountry Hunters and Anglers every September celebrates Public Lands Month. And one of the things that we do during that time is called Public Lands Packout. And that's sort of a chapter by chapter, maybe a little bit of a bragging rights competition to encourage our members to go out and, pull trash off of public lands, whether that's, beer cans and spent shells, at the wildlife management area parking lot, all the way up to, we've had chapters that have pulled like old cars out of the woods and all sorts of crazy stuff. And it's cool to see. But definitely important as we are out on our public lands and our public waters to make sure that we're acting as stewards and leaving them better than we found them. I want to, I think, shift a little bit at this point and talk about the legislative process here in Rhode Island, because that's something as I, as an advocate for backcountry hunters and anglers, I've sort of, developed my knowledge of over the years. And at this point, I feel as though I understand pretty well, but I wanted to sort of make some knowledge on that available through you, Terry. So if you could you give just a high level overview of, I mentioned that we have a couple bills in the General Assembly right now on this issue, but what's the path for those after they're sort of introduced to end up becoming a law? What needs to happen for them to become a law that's, that's on the books?
So we've had the hearing in the House. The Senate will have to have its hearing. And then the bills are at that point become they belong to the committee. They no longer really belong to the sponsor, myself. Now they're in the House side, they're in the Judiciary Committee. So, and that's Chairman Craven. So Chairman Craven needs to really be persuaded. I as the sponsor, I can still continue to advocate for my bill, but Chairman Craven needs to advocate for it too, and needs to advocate to leadership that this is a priority bill. And so to encourage them, they need to hear from members of the public, and Chairman Craven needs to hear from other reps that they are hearing from members of the public. Because right now, the reps that are hearing from property owners are all filtering those emails to me, but we need people on the other side. We need to implore them. And so if this is something you're passionate about and want to support, you need to contact your representative, and you need to contact the Judiciary Committee. And you might want to actually send a letter to the speaker too, and let him know that this is important. And that's going to be the way we have to get organized, and we have to show that there is enough, there's enough demand for this. And I look to what really convinced me that this is a good thing to do is looking back at the outcome of that election that determined the constitutional changes in 1986. It was 69.8%, I think. Nobody passes, elections aren't won like to that. They're much more evenly dispersed has been my experience. So to see something so overwhelmingly supported, I believe there's more people out there that would support this. They just don't know about it. So we need to get the word out and implore people to, get involved and let their voices be heard.
So I wanted to talk a little bit about something. I think it's a little bit unique to Rhode Island, and I've heard in the committee hearings a little bit of clarification on this a number of times already this year. But the typical process that I see in the committees here in Rhode Island is that when, at the beginning of a hearing, they'll sort of list off all the bills, and then they'll hold a vote to hold them for further study. Right. And I've seen people, people look at that and, immediately they sort of, deflate and think, oh, the bills are dead, that, they've been tabled and we're not going to ever see them again.
Not necessarily the case. Could be the case, but we can't make that decision now, and we shouldn't make that assumption at this point, because the bills are heard for further study, to give the committee time to ponder them, to give the public time to weigh in. Sometimes there are stakeholders, and the stakeholders get together with the sponsors and with the committee members, and they might want to hash out, there might be some opposition, and you would want to hash out some kind of a truce or I don't know how that's going to work with this, except maybe putting some of the fears at ease of the property owners, and just making it a little more clear about where this does not apply to. And that's my thinking right now. And I've talked to Chairman Craven about that, and need to work my way up the chain with what my suggestion would be to strengthen the language a little bit more to put the property owners at ease.
And Terry, if I can suggest as well, I was thinking about this more, if we included a specific reference to the recreational use statute, that would just take that right out as well.
That's a great idea.
Just cross-referencing it to the other law that currently exists, just tacking it onto the phrase regarding the CRMC rights of way, that would be a beautiful way to handle it, to make sure that it's right up front as we're thinking about this issue. You'll be relieved of that burden. Don't worry about it.
That's a great idea.
And I just want to clarify sort of for the audience, the recreational use statute is what Dennis was referring to earlier, that limits the liability of private landowners when they open up their land for access to the public for recreational purposes.
Correct.
Is that correct? Is that correct, Dennis?
That's right.
So did anybody have, so does everybody on this call, do people know how to find their reps? And that's I think it's a basic question, but.
Yeah, so I want to circle to that, but I got a couple of things I want to cover before we sort of arrive at that destination.
I just don't want to forget about that.
No, no, that's close to the punchline. So circling back to the held for further study, you sort of mentioned that, we've had this hearing already in the House, and we gave a bill number for the Senate, but that has not had a public hearing yet. Right. You mentioned that after the bills are heard during that sort of first introduction to that public hearing, the first consideration, that they're held so that we can continue to seek input from, from stakeholders, from members of the public. And so that sort of implies to me, and I want to, ask directly, but that there still is an opportunity for people, even though there's been a hearing, to sort of engage with their representatives to make sure that they know that this is an important issue and to let them know how they feel about it.
Absolutely. Absolutely. Now's the time. Yes. Yeah, we should not give up. And there's a new, on the House side, I don't know, the Senate is still working through their rules, but on the House side, we have a new rule that actually lets each rep choose 3 bills out of their inventory of bills to keep alive into the next year. So they would have a 2-year lifespan, during this 2-year session. And I don't think anybody's really figured out the advantages, the political strategy behind how we're going to use that, but that is something, a new rule that the House enacted. So
Sure.
I'm not really sure what that means yet, but it's there.
So you had mentioned, Terry, that there are sort of a number of key players in the process of, of a bill becoming a law, those being the committee chairman, the Speaker of the House, President of the Senate, and then ultimately it's going to end up needing to go to the governor to get signed. Can you sort of give a little bit of direction on who's the appropriate audience? If, I as a constituent want to see this thing become a law, should I be reaching out to all of these people, or should I be reaching out to my representative? What's the most effective audience?
I think I think there's three piles. I haven't really considered where Governor McKee is yet. We have a brand new governor, and there's a lot of state departments that don't know how he feels about a lot of different things because he's only been the governor for 4 or 5 weeks now. So then he's in the middle of a pandemic and he had to get the budget out in a week. So there's a lot of unanswered questions around what his feelings are on a lot of different things, frankly. But I would say writing to the Chairman Craven, and there's one email address actually for the whole committee, and you could use that and write to the Judiciary Committee. They all get it. I think they are still posting them online on the state website. You can go to committee documents, go under Judiciary. You will have to wade through a whole lot of gun bills letters now. But if you look for the H5469, you can read the letters that have come in on this bill. Some of them, there's dates with them too. And I don't know what they're doing with the letters that are coming in now, frankly, but you could go back to the date of our hearing back in February and see the letters that came in at that point in time, at that location. And you could also email the Speaker, Speaker Shikarchi. He has an email address, which I think is speaker@rilegislature.gov. And you should definitely email your own representative. You should really call your own representative, in my opinion, because I'm hearing from property owners, the property owners that are going to be cranky about this, they know who their representatives are and they know how to engage in all likelihood, and they know who to contact, and they are. So I would tell all of you, your vote is just as important as anybody else's. So make your voices heard.
Of course. And I want to sort of ask a similar question, but from a little bit of a different angle. Obviously I volunteer for a group that has, a range of constituents and a range of districts. I know that Rhode Island has got, a number of local surf casting clubs, angling clubs, and then other user groups that might have an interest in access to the shore, like surfers or, wildlife photographers and bird watchers. What's the best way for larger groups that have a wide range of constituency to get involved, sort of as an organization as opposed to as individuals?
I suppose doing stuff like this evening, and getting the message out, however you communicate to your membership in Rhode Island. We could make references, links to the bills, links to the email addresses, anything that could help connect your members to the players we just defined, the people we just defined, the Speaker, the House Judiciary Committee, and people's individual representatives. I think it's all about education. There has been some press. There is the Public's radio has Alex. What's his? I will look up if somebody else talks about something else for a minute. There is a press person that's been following this issue, and I'm sure you know his name. And his first name's Alex, but I have two Alex, two press people with both with the same first name, and they've been contacting me on various things. So I got to double check his last name. But just the press is good. It's great. We should have probably invited some press here tonight.
We will have a minute later. I've seen a couple questions come in that I think we'll direct to Dennis later, once I get through the sort of the end of this section. So you'll have a couple minutes at that point. I do want to sort of wrap up this section by talking about the tools that people can use to learn, who their elected officials are if they don't know that information already, and then how they can get in touch, what the most effective ways to get in touch with them are.
So you can go to vote.sos.ri.gov. That's the part of the Secretary of State's website. And you can check your voter information. And that will tell you what district you're in. You could Google then, you might have to take 3 little steps. I'm not sure if Secretary of State, it will tell you what district you're in and your precinct number, but I don't think it gives you the name of your representative. I think you mentioned that your organization has an application that might get people to that information quicker. But then the General Assembly has a website, and when you find your representative, their email address is there and their phone number is there. And that's how you get their contact information.
So I will give a little plug for backcountry hunters and anglers here. We also have a tool on our website, backcountryhunters.org, that helps individuals to find who their elected officials are and to get in touch with them. That resource is on our website, backcountryhunters.org. And at the top, there's a tab that says Take Action. If you go to that page and scroll all the way to the bottom, there's a little dialogue that where you can put in your street address and your zip code, and that will pull up your elected officials all the way from the President of the United States down to your I think it just goes down to state level representation, like your representatives and senators here in Rhode Island. That's at the General Assembly. And whatever state you're in, it will show you who represents you in the legislature locally. I do want to leave a little bit of time for question and answer here. And I know I have a couple that are on my list, but I wanted to sort of get sort of a closing thought from both you, Dennis, and Terry on the question of why is this needed? Sort of what is the fundamental problem that if we pass this law, we will not have it this year or any year in the future?
Well, as we've described, we're trying to, reduce the chances that we're going to have these altercations. And I think there's a lot of forces at play that are going to make these along the southern shore with the erosion and sea level rise. I think this is just going to become more heightened. And so we should define this. It's kind of left open. It's kind of hanging, and we should resolve it in a way, a rational, reasonable way that just lets people live together peacefully and lets, Rhode Islanders take advantage of what their constitutionally, their privileges are. It's a shame that we live in the ocean state, and people should be able to walk along the beach and that should be that in my mind. Dennis?
Well, I couldn't agree more, Terry. I've been plugging away on this issue since 1975, as I said earlier, and it's been a major disappointment in my professional life as well as personal that we haven't really figured this out yet. We spent a lot of time on the Constitutional Convention trying to nail down those rights, but because of the vagaries of figuring out where this boundary is, the public has never been able to effectively use the rights they were granted in 1986. But by taking away the power to criminally arrest someone, finally, you're going to restore the balance between public and private rights that we were trying to do in 1986. And remember, as Terry said, this was an issue that passed with 70% of the vote. And if politicians can count to 10, and they know that 7 people think this is a good idea and 3 don't, This maybe
That's
has a
right.
chance of passage.
We just got to get those 7 people to tell their representatives that they care.
That's right.
Awesome. I appreciate both of those sentiments, or both of those pieces. I want to sort of transition to some of the comments and questions that have come up. I see one about our neighbors to the west in Connecticut. They've established sort of an on the ground, or a boundary for on the ground enforcement, which I think is what, that's really what we're talking about here. I know you have sort of a perspective that spans a wide area, Dennis, through your career and your body of work.
Mhm.
Do we have any idea how that measure has succeeded in Connecticut at helping to minimize conflicts or solve things sort of on the scene as opposed to in the courts?
I'm afraid I don't have any information on the Connecticut example. I do know that among all the states of the US, Rhode Island is pretty much in the middle in terms of shoreline rights. The most liberal being the state of Oregon and Hawaii and the jurisdiction of the Virgin Islands, the territory of the Virgin Islands. On the most conservative would be the state of Maine, where the private property owner gets to, in Massachusetts, gets to own down to mean low water. And as a result, the public can only appear even in the intertidal zone for the rights of fishing, fouling, and navigation. And so just the simple passage along the shore is not allowed. And so it's recommended by the Attorney General in Massachusetts, if you want to walk along the shore, you should walk with a fishing rod over your shoulder and have the intent to fish, in which case you cannot be arrested. So it's bizarre how, we think we're one nation of laws, but state by state, we're really very different. But we are, as Terry said at the outset, the ocean state. A lot of the reasons that many of us moved to the ocean state was because of the beautiful Narragansett Bay and the South Coast beaches. And the idea that a very small percentage of the population gets to control access in an area where the state has held in the past is part of the public domain. It bothers me every night. And I really want to get to the end of this and decriminalize an activity that never should have been criminalized. I saw one of the questions in the chat. What do the police think about this? The police don't want to get involved in these disputes. It's a horrible position for them to be in. Their wealthiest local taxpayers saying, I demand you come down and arrest that ruffian along the shore. And, that's just not a good position for that young patrolman to be in. The police chiefs don't like it when their decision is later overturned. And then their town insurance has to pay $25,000 because of an unlawful arrest. This is stupid. We can't let this go on. We've got to fix it.
I've got another question here. This is about recreational use. Would the owner need to declare an easement to reap sort of the benefits or the exemption from liability that's granted under that, or is that implied somehow?
Well, as I suggested earlier to Terry, I think one of the amendments that I would think would be a friendly amendment to the bill would be to say that if someone is exercising the rights according to the statute, their activities would be covered by the recreational use statute, period. That's all you need to say. So a little refinement on what that first draft was. And that's why you have the hearing process to come up with refinements that make the bill a better bill. And I think that would make it clear from the outset that this is not something that they have to worry about.
Yeah, I want to add a little sort of perspective from another angle, as somebody that, hunts in Rhode Island, and I also hunt out of state. Most of the situations I think that we're talking about here, especially when we're talking about trespassing, is not just, sort of an open beach that, that you can walk across. We're talking about properties that have, posted no trespassing type signs. And when you do that, posting no trespassing, that, that sort of is a clear indication that this is not for, public use. And that's where, sort of the intersection here occurs.
If they're in that strip, those no trespassing signs would not apply, and they really shouldn't be there.
Yeah.
if they're in that lane that we're talking about.
It would be like me putting up a no trespassing sign in Goddard Park.
Yeah.
Or on the
exactly.
sidewalk.
Yeah, right.
The
Forget
sidewalk,
about it.
that's, the sidewalk is a perfect example. And actually, somebody from Save the Bay was talking to me the other day, and he used that analogy, is that we are creating a sidewalk along the beach and nobody goes out. The homeowner is responsible to shovel that sidewalk and to keep it clear, but nobody goes out there and says, you can't walk across the sidewalk. So that's kind of what we're doing, is creating a sidewalk.
It's a reasonable accommodation.
That's right.
And I'll add that it's an accommodation that, that is also the accommodation of a right that's granted in the Constitution.
Right.
Yeah.
Another question that came in, what sort of is the concern for shoreline property owners that might have, personal property within that, that boundary that we're talking about allowing passage across? If you leave a beach chair out, or is that something that there's any thought on, sort of the intersection there?
I have heard people complain that their toys might not be, as secure, but don't sit on the chair. Avoid the, what are you gonna say? There's one place in Portsmouth, not too far from where that photo was taken, where there's actually some railroad tracks that travel between the homes in that area and the shoreline. And I know that there are people that are in the homes that own the other side of the tracks, but they are trespassing over the tracks to get to the other side of the shore where they put their Adirondack chairs and etc. And I do think they own that stretch, but the access point is not over the tracks. It's way down at the other end, but that's in all likelihood by the visual pathways from the backyards to the other side, to the water side. That's not the way that is traveled. So there's trespassing on more than one way.
When I bring my private property when I ride my bike down a bike path, and I decide to stop and go in and get an ice cream cone off the bike path, I lock my bike. And if you've got private property that is along, as Terry has said, that public sidewalk along the shore, and you're concerned about being stolen, then you put a chain on it. It's not very hard.
Yeah, that's an interesting analogy that I don't think I had heard before this meeting. That I think is going to round out the list of questions that I had come through here. We're running a little bit over an hour at this point, so I want to sort of wrap this up. But as we've sort of gone through this conversation and provided some of this information about the issue at hand, and then about how folks can involve themselves with getting this through the legislature, I want to sort of take closing thoughts from both of you guys, or a message to folks that they should get involved, and why this should matter to them.
Well, I think everybody here has logged in because they care about access to the shore. And so I think it's something for all Rhode Islanders to care about. You might not, we should preserve this. We shouldn't let it slip away, because the further it gets away from us, the harder it would be to recapture it. So I would say better to keep what you have now. And that's my view of it, because it would be, it could become more difficult down the road. So we should, make the push for it now.
I'd have to agree that we have a window of opportunity here. We've got a good bill. We have a chance of moving forward. It's not some frontal assault on property owners. This is a minor tune-up in the state's criminal law that will enable all of us to get better access along the shore. to remove what it was a bit of unfinished business from 1986. I've been working on this issue now for 46 years, and this is a big, serious bit of unfinished business that I have that I'd love to see resolved soon, because I don't have 20 more years to work on this. And I would really love to see us get to a resolution of this in the near future, so that it's clear for my kids and my grandkids.
Exactly. I just found out a couple of months ago that I'm going to be a grandmother, so I've got a long range plan too.
There you go.
Congratulations.
Yeah.
Okay, well, thank you. Thank you, Terry, and thank you, Dennis, so much for coming on tonight and making this information available. Before we close out, I do want to just give a couple minutes on how folks can get involved with Backcountry Hunters and Anglers and how they can stay in touch with what we're doing. We have, as I've mentioned, a website, backcountryhunters.org. And within that website, there's a chapter section, and you can click on any of the New England states, and that will get you up to date with what we're doing here, events that are coming up, and issues that we're working on. The New England chapter also has a Facebook group. If you search for New England chapter of Backcountry Hunters and Anglers, you'll find us on Facebook. And on Instagram, we're at New England BHA. We're also looking always for new members. Membership costs $35 a year, so it's not a whole lot of money. And with that membership, you will get our quarterly magazine, Backcountry Journal, and also you'll support the work that we're doing here in Rhode Island, in New England, and then across North America to protect access to public lands, waters, and wildlife. And right now we're running a promotion where when you get that $35 annual membership, you'll also get a $25 public landowner t-shirt included. You have to search for that specifically, but it's at backcountryhunters.org/free PLO shirt. And so if you want to join up, I would encourage you to take advantage of that and let people know that you're a public landowner when you're out there. So again, thank you all for showing up. Thank you, Dennis, and thank you for Terry for hopping on and making this information available. And I hope to see everybody at a hearing soon, and then out on some public land soon after that.
Absolutely. Thank you. Thanks so much for having us.
Thank you for hosting it. Yes.